common man has absolute faith on the judiciary indeed. We all know about Keshavananda Bharati versus State of Kerala, Minerva Mills case. Democracy has been saved. In fact, when the democracy was in crisis because of legislative and executive. What was the comment of the Honorable Vice President, Jagdeep Dhankhar? What is happening in the country? Question mark. We have bargained for democracy for this day. Article 142 as nuclear missile is definitely a problematic statement. Enforcement of degrees and orders of the Supreme Court and orders as to discovery, etc. Article 32 of the Constitution of India, he said, is the soul of Indian Constitution. Governor was sitting on 10 bills, not less than 10 bills, for more than Article 142 is not the power conferred by the government on the Supreme Court, considering the fact. My dear friends, Honorable Vice President of India has made a comment about Article 142 of the Constitution of India. That is about the power of the Supreme Court. My dear friends, with due respect to his comments and observation, what we need to look at is his comments have become problematic today in the country. In fact, my dear friends, his comments have actually questioned about the common man's faith on the judiciary. I would like to clarify to everyone, common man has absolute faith on the judiciary indeed. The only reason is, out of all the three organs of the Constitution, that is legislative, executive and judiciary, judiciary protects the fundamental rights of the common man in this country. My dear friends, the citizens are today having a peaceful sleep in this country. It's because of the power of the judiciary, and judiciary has time and again has established the democratic principles in this country. We all know about Keshavananda Bharati versus State of Kerala, Minerva Mills case and Golaknath's case. And from the time of the first constitutional amendment in this country, each and every time the democratic aspect has been, democracy has been saved. As in fact, when the democracy was in crisis because of legislative and executive in 1970, it is the judiciary, based on the observations as part of Keshavananda Bharati of the State of Kerala, has upheld the democracy and established the democracy again in this nation. My dear friends, when the judiciary has transformed this nation over a period of time, and we are in the year of 75th year of Constitution of India, the Constitution evolution has been possible not just because of legislative and executive, but because of judiciary. That means the common people have faith in this country. It's only because of the judiciary. My dear friends, what was the comment of the Honorable Vice President, Jagdeep Dhankhar? My dear friends, the comment that he made was, I wanted to quote the exact comment of Vice President Jagdeep Dhankhar. He said, I quote the exact words, there is a directive to the President by the recent judgment. Where are we heading? Question mark. What is happening in the country? Question mark. We have bargained for democracy for this day. President being called upon to decide in a time-bound manner, comma, and if not, becomes law, full stop. So we have judges who will legislate, comma, who will perform executive functions and who will act as super parliament and absolutely have no accountability because law of the land does not apply to them. This was a statement made by Honorable Vice President Jagdeep Dhankhar. With due respect to his views, what we need to understand, this observation can never be acceptable. It has become problematic actually. My dear friends, calling 142, Article 142 as nuclear missile is definitely a problematic statement. The reason is, Article 142 is a power not just conferred by the government. My dear friends, as per Article 142, for the benefit of all of you, if you look at Article 142, enforcement of degrees and orders of the Supreme Court and orders as to discovery, etc. I quote the exact words of the Constitution of India with respect to Article 142. Article 142, Clause 1, Supreme Court in the exercise of its jurisdiction may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it, and any decree so passed or order so made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament, and until provision in that behalf is so made in such manner as the President may by order prescribe. Article 142, Clause 2, subject to the provisions of any law made in this behalf by Parliament, the Supreme Court shall, as respects the whole of territory of India, have all and every power to make any order for the purpose of securing the attendance of any person, the discovery or production of any documents, or investigation or punishments of any contempt of itself. My dear friends, this is the power under Article 142 on the Supreme Court of India. And we have to understand this power on the Supreme Court is provided by the Constitution of India. In fact, the Constituent Assembly when they debated about Article 142, before providing these powers to Supreme Court, they did analyze what are the reasons because of which this power has to be provided to the Supreme Court. In fact, Bharat Ratna Babasaheb Dr. B.R. Ambedkar had an extensive deliberation and discussion as part of the Constituent Assembly debate, being a chairman of the drafting committee, and finally arrived that the power has to be provided to the Supreme Court because he didn't give this power in silo, but he gave it along with Article 32 of the Constitution of India. Article 32 of the Constitution of India, he said, is the soul of Indian Constitution because the power of judicial review, read with Article 142, the power of the Supreme Court, it can pass any order with respect to declaration of law. And third important article which also provides power to the Supreme Court is Article 143. If you see Article 143, it shows when there is a question about a law or a constitution of this country, the president can approach the Supreme Court. In fact, and as per Article 143, the power of president to consult Supreme Court. Under that, Article 143 clause 1, if at any time it appears to the president that a question of law or fact has arisen and is likely to arise, which is of such a nature, of such public importance that it is expedient to obtain the opinion of the Supreme Court, upon it he may refer the question to that court for consideration, and the court may, after such hearing as it thinks fit, report to the president its opinion thereon. To add to that, Article 143 clause 2, the president may, notwithstanding anything in the proviso to Article 131, refer a dispute of the kind mentioned in the said proviso to the Supreme Court for opinion, and Supreme Court shall, after such hearing as it thinks fit, report to the president its opinion thereon. My dear friends, as per the constitution, scheme of the constitution, the Supreme Court has the ultimate power, has enormous power. In fact, certain times the president itself can take the advice of the Supreme Court. That shows the authority of the Supreme Court with respect to the Constitution of India and shows the supremacy of the Supreme Court with respect to the Constitution of India. Accordingly, Article 142 is not the power conferred by the government on the Supreme Court, considering the fact the judiciary in Constitution of India is independence of the judiciary. It is not the power conferred by the government. It is the power conferred on the Supreme Court by the Constitution of India. My dear friends, observation by Honorable Vice President of India came because the Supreme Court has come out with a recent judgment about governance. This is the judgment that came as part of State of Tamil Nadu versus Governor. The petition was filed by Tamil Nadu government, wherein the timelines with respect to deciding on a bill was provided as part of the Supreme Court judgment. If you look at Article 200 of the Constitution of India, with respect to timelines on deciding on a bill passed by the Legislative Assembly with respect to governor, the wording used is as soon as possible. You can look at Article 200 for benefit of all the people who are interested in law, not just law students. You have to understand there was no timeline at all as per Article 200. But Supreme Court took all the efforts to help the legislators with a timeline. Because at the end of the day, the legislator gets elected with the mandate of the people. When they come to power, they have to legislate. They have to pass laws. They have to get the law bill assent by the president in case of the union, and in case of the state, they have to be assented by the governor. When that is the kind of a scenario, the Supreme Court took all the efforts to support both legislator as well as executive. Accordingly, using the powers under Article 142, the Supreme Court has passed an order by providing timeline not just for the governor with respect to assent of the bills or withholding and sending back to the state assembly, or with respect to reserving to the president. It also gave timeline with respect to the president to decide on the bill. And if the president gets the bill, after the governor withholds his assent and sends back to the assembly and gets back the bill, the only choice for the governor was to give an assent. But without giving an assent, if he sends to the president, even if the president has signed it, it becomes unconstitutional, is what the Supreme Court decided. In that case, this can be interpreted to say it is unconstitutional. Ultimately, as per Article 142, the Supreme Court has the power not just to legislate but to declare law. So that is here the Supreme Court, the judiciary, has taken all the effort what the legislators should have done to actually define timeline. This timeline debate is going on since the inception of Constitution. In fact, before Bharat Ratna Babasaheb Dr. B.R. Ambedkar being a chairman of the drafting committee, when the Constituent Assembly members debated, they indeed wanted to have timeline as part of Article 200. But Bharat Ratna Babasaheb Dr. B.R. Ambedkar wanted to provide the phrase as soon as possible, Because as soon as possible means as quick as possible. Moment the bill comes to the governor, he has to give an assent. In fact, he can give it on the same day. Instead of providing timeline, he provided a phrase to show urgency on a matter. But whereas, take for example Tamil Nadu governor was sitting on 10 bills, not less than 10 bills for more than 20 months. That shows the action of the governor being unconstitutional, because as soon as possible means as quick as possible. That is what we have to understand. That shows the urgency provided by the Constitution, Article 200. So, my dear friends, the Supreme Court took all the efforts to provide timelines, not just to the governor, but to the president. In fact, the legislator and executive should have been happy, wherein the Supreme Court has went on to provide the timeline. So, by looking at it, the observation provided by Honorable Vice President of India, Jagdeep Dhankhar, it may not seem to be acceptable, because people have so much faith on the judiciary, and every day the fundamental rights of the citizen is protected only because of the action of the judiciary, not just because legislative or executive. My dear friends, it is also very important to understand President of India is a titular head. The President performs functions as per the aid and advice of the Council of Ministers as per the Constitution of India. Similar is the case of the governor also. Governor acts on the aid and advice of the Council of Ministers of the state. It is the Constitution which says when the bill is given to the governor for his assent, he can return the bill to the Legislative Assembly. But once the Legislative Assembly reenacts the bill, the governor is bound to give his assent. It is what the Constitution says. Similarly, the governor has the right to reserve the bill for the president's consideration, but it is the union cabinet that will aid and advise the president for it. It is not the president's personal right to whatever they want to do. That means president has to be advised by the Council of Ministers, aided by the Council of Ministers. How can there be an exception with respect to governor alone? So, my dear friends, this attack on the judiciary is just not attack on the judiciary, but indeed on the independence of the judiciary, which was upheld as part of the Keshavananda Bharati as the state of Kerala. Considering all these facts, we have to understand common man today has a faith on the Constitution, and when I say Constitution, he has a faith on the judiciary more than the legislative and executive. That can be understood because whenever a common man's right is affected, he immediately thinks about approaching the court. So at no point of time in this nation, the common man will lose a faith on the judiciary. They may even lose faith on the executive. At no point of time, common man will ever lose faith on the judiciary. Thank you so much.